The California Privacy Rights Act of 2020, CPRA, is a California ballot proposition that expands California's consumer privacy law and builds upon the California Consumer Privacy Act, CCPA, of 2018. It was approved by a majority of voters after appearing on the ballot for the general election on November 3, 2020. CPRA History and Summary. The California Privacy Rights Act, CPRA, is a new statewide data privacy bill passed into law on November 3, 2020. It expands upon the existing California Consumer Privacy Act, CCPA, that took effect on January 1, 2020. The CPRA strengthens rights of California residents, tightens business regulations on the use of personal information, PI, and establishes a new government agency for statewide data privacy enforcement called the California Privacy Protection Agency, CPPA, among key changes to the Golden State's data privacy regime. The CPRA becomes fully effective on January 1, 2023, and enforcement is scheduled to begin on July 1, 2023. Timeline for California Privacy Rights Act, CPRA. January 1, 2021, California Privacy Rights Act, CPRA, goes into law and the California Privacy Protection Agency, CPPA, is established. July 1, 2021, process for formulating and adopting CPRA regulations begin. January 1, 2022, PI collection becomes liable under the CPRA's one-year look-back period. July 1, 2022, deadline for final CPRA regulations to be adopted by the CPPA. January 1, 2023, CPRA enters into full force. July 1, 2023, enforcement of the CPRA begins under the CPPA. How companies got impacted by the CPRA. The CPRA changed the definition of business to exclude smaller businesses and include bigger businesses that generate a large income from the collection, sharing, and/or selling of Californians' personal information, PI. The CCPA imposes obligations on businesses, service providers, and third parties. The CPRA adds a fourth category, contractors. How is a business defined? The CPRA defines a business as a for-profit legal entity that collects consumers' personal information on its own or by others on its behalf. That alone or jointly with others determines the purposes and means of the processing. That does business in California and satisfies at least one of the following thresholds. Has annual gross revenues in excess of $25 million. Annually buys, receives, sells, or shares the personal information of 50,000 or more consumers, households, or devices. Derives 50% or more of its annual revenues from selling consumers' personal information. Overview of a business responsibilities to be CPRA compliant. In order for a business to be CPRA compliant, a business must provide notice of consumer rights, honor consumer rights, fulfill disclosure and retention obligations, facilitate consumer requests, implement security safeguards. If you liked our video, do like, subscribe, and share.